All Missourians should be concerned about litigation funding because at the end of the day, it's going to impact their bottom line. It's going to impact the cost of courts. We all are mindful of what the costs are involved with court systems around the country. Litigation funding has the potential, I think, in any state to drive up the cost of litigation, protracts litigation in a way that we don't want to see happening, therefore expanding and increasing the cost of running the court system. It also encourages frivolous litigation. If you've got frivolous lawsuits being filed because there's piles of money out there to fund the litigation, it's going to increase the number of cases that are in the court systems. At the end of the day, it's going to cost taxpayers more money than we should be paying. So let me tell you how I come to this issue. I get this question all the time. I served, fortunate for me, I served for 13 years as the Attorney General of my state, Georgia. During that time, I also served as president of the National Association of Attorneys Generals. And it was during this space and time that I got a chance to see lawsuit lending problems up front. And I was disturbed, not only because of the impact that it was having on consumers. It's just not fair to see consumers get charged 150, 300% interest rate on anything. That's why we have usury laws in our states to protect consumers. Every state has usury statutes. But I saw that happening all over the country. Not only that, but I saw legislators looking around and trying to grapple with these issues. And so I had firsthand experience with it. After leaving the Attorney General's office, though, I had the great opportunity to start working with the U.S. Chamber. And so I move around the country now, talking to state legislatures, talking to chambers of commerce about the problems associated with lawsuit lending. Fortunately, we've been well received. When we explain this issue, people tend to be very supportive of it. It's a great opportunity not only to create a good system, but I think a fair system, fair for consumers, fair for businesses, fair for our court systems, is something that we all have to be very mindful of. Historically, this matter has been dealt with through the old common law themes of maintenance and champerty, where the law said one couldn't get involved in another person's lawsuit by lending money. You just couldn't do it. But those common law concepts have sort of been watered down. And all across the country, we're seeing legislative bodies, court systems, attorneys generals. I was the attorney general in my state for some 13 years, so I saw this happening. All are now getting involved in this process. And so what we have to see on the legislative front are legislators who, first of all, understand the issue. This is $1 billion industry out there that's costing the court systems, costing businesses, costing consumers more than they should have to pay in these type cases. So we've got to have legislators who understand the process, are willing to weigh in and exact some type of control, not only on when these cases can be filed, but the interest rates that are going to be involved. All across the country, we're seeing battles on the legislative front now. Just over since 2010, those of us who have been opposed to these exorbitant interest rates that are attached to lawsuit lending matters, we fought back in almost 10 to 12 states, industry-funded bills, where they wanted to exact these kind of measures. But these challenges are across the nation right now, and we've just come out of a battle in Tennessee where we were able to create some legislative efforts there. Now a bill is in place that imposes a cap on the interest that can be charged and creates consumer safeguards that should be present in all of these bills. But no question about it, the battles have now moved to the legislative front. We're all talking about it. It's something that won't go away, but something that we've all got to pay attention to. Now, we all want to make sure the legitimate cases are settled early and out of the system. Businesses should be concerned about that as well. The problem with litigation funding is it protracts litigation. It allows those people who are in the process of litigating to hold on to those cases, in many instances, longer than they should, not settling because now they've got a larger payback. They've not only got to pay their contingency fee lawyer, but they've also got to pay the lawsuit lending. So you add the 30% or 30, 3 1/3% that the contingency fee lawyer is going to get on top of whatever deal the litigation lender is making with the consumer. In many cases that will cost the consumer upwards of 150 to 300% interest rate. When you add both of those things together, you've got a big number. And so litigants are less likely to settle, therefore protracting litigation, therefore causing businesses to be involved in litigation for a much longer period of time. That's not right. Be supportive of your state and local chambers. The chambers have been out front working on this issue because it is one that tremendously impacts business around the country. So I think anyone who's interested and want to see this process work effectively should be engaged. They should be talking to their legislators. They should be supportive of chamber-backed bills that will create an atmosphere of fairness that protects consumers and businesses alike.